In this fifth video, I'll use my robot friends to explain what happens on your first court date. Right now, the rage is to use ChatGPT and other artificial intelligence to create video content. While I use my robot friends to speak for me, I personally created this content. Until this video, we have been discussing the DMV hearing process and your driver's license. Now we will begin to discuss what happens at your first court hearing. You only need to attend the hearing if we have specifically told you to. I am often asked if it appears better for you if you arrive nicely dressed for your court date. The answer is that it doesn't help you because the court sees hundreds of cases daily. However, if you need to attend court, please dress to impress. When the first court date arrives, we appear for you and ask for the police reports that the prosecutor used to decide whether to file charges against you. After redacting, we will make copies of the reports and send them to you. We are required by law to remove the address, phone number, and identifying information of any civilian witnesses. If you come across any blacked out or blank sections, they contain details about civilian witnesses you are not authorized to access. We are not permitted to provide you with this information. Unless we have discussed otherwise, your first court date will be delayed so that we can review the additional information we receive. We sometimes need to continue the case for a pretrial to obtain body-worn cameras and other evidence. So, when you call us in a panic, dying to find out what happened on your court date, the easy answer is that we delayed it so we could work some more.
Many of my clients are concerned that they have expressed reasons that they are not guilty of the charged offenses, and they want to know why their case was not dismissed on the first court date. The simple answer is that the court works differently. Suppose we have evidence that we can use to try and convince the district attorney to dismiss your case. We only use that evidence when we are either confident that it will work immediately, which is very rare, or we use that information to get the prosecutor to file different charges before the case ever makes it to court. If you have evidence that we believe will result in your acquittal, then we will use that evidence only after we have reviewed everything the prosecution has to ensure that they don't have something that will negate your proof of innocence. The bottom line is that if we use it too soon, it often fails to work correctly. The review process can take a matter of days or months. It takes days when the evidence is overwhelmingly against you. For example, if your blood alcohol level is dramatically over the legal limit. The process takes much longer when we must obtain the calibration records of the devices that were used to test your blood alcohol level, or to review the body-worn camera to see how well you performed the field sobriety test. If you want to get the case over with and don't want these delays, please let us know so we can speed the process up. However, we typically spend 2 to 4 months after your first court date to evaluate whether some defense might be successful for you. Sometimes, I'm a mind reader. Some of you are likely wondering whether your case will take 4 months or less to answer how strongly we feel the evidence is against you. The bottom line is that we must read and look at everything to answer the question. Once again, your best option is to be patient, and if you have specific needs that we need to know about relative to how long the case takes, please let us know. In our next video, we will discuss how to evaluate the police reports that you receive from us after your court date and what we are looking at. Until then, please keep working on yourself and focusing on the future.
This is David Lehr, founder of Strongest Defense, and we appreciate your time. If you have any questions, please contact us at the office, and thank you for listening.